Good morning to all of you. Law of Torts, right? So, friends, in the last video, we have discussed the topic of vicarious liability. Now, we are going to discuss a few cases relating to vicarious liability in relation to master-servant. You can call it as principal agent also, but as a master-servant relationship. Two cases we are going to go. One is a positive example and the second one is a negative example. First one is Lloyd versus Grace Smith&Co. 1912. Mrs. Lloyd, she was a landlady, she was having two cottages and she wanted to dispose of the same. Therefore, she approached the real estate firm, Grace Smith&Co. and the firm sent their deputy or their employee to the house of this woman. So madam told him that she wanted to dispose of these two cottages. Then he has given a method. He said, madam, you please sign here. We will convert into sale deeds and we will dispose the property and we will get back to you and we will give the money. Like that he promised, made a false promise to her. But days are going by, the man has not come and there is no information as to whether the properties were disposed or not. Ultimately, she moved around the Grace Smith&Co. a couple of times, but the person was not found. What happened? So the clerk sold the two cottages and misappropriated the amounts because he converted them as gift deeds and he sold away the properties. Right? Ultimately, the House of Lords held that even though the clerk embezzled the amount for his own purpose, since he acted during the course of employment, the defendant is liable, the company is liable. Because the argument was like this: she approached your company, you have sent your deputy, and he was in the discharge of his duty. No doubt he embezzled, then it is your duty to repay the amount to her. This is a positive example for vicarious liability. Why Grace Smith&Co. was held liable? Because of the relationship between the company and the employee. Okay, I think you know understood it. We will go to the second case. That is State Bank of India versus Shyama Devi, 1978. So here both of them are, both ladies are victims. Shyama Devi, actually in the house of Shyama Devi, a State Bank of India employee by name Kapildev Shukla, he was residing for rent actually. And normally, since he was a bank employee, right, Shyama Devi has got trust in him. So she used to get money drawn in her name from the bank and he used to give back the money and she used to give a check to him and he has to get the cash. He used to deposit her money. Like that, lot of transactions have taken place. Please remember, she did not go to the bank. She did not end the transactions were being, because normally we believe in people. Suppose if a bank man is residing in a house for rent, normally we say like that, but I don't say because normally I don't have any work. So therefore I go to the bank, spend a few minutes and with chit-chatting the public and know the environment, know the things happening in the bank also. But some people normally because of the old age and because of the so many reasons they may not be able to go. And here the confidence, if you remember, the confidence of Kapil Shukla made her there is no necessity to go to the bank. But ultimately the defendant gave her check to deposit in her account. But our Kapil Dev, not cricket Kapil Dev, this Shukla, Kapil Shukla misappropriated the check amount. So the matter went up to the Supreme Court level because bank people said, no, it's not in our area because you have not done any transaction in the bank. It is, suppose if he is in the bank, if he is on duty, we will be held responsible. Suppose if he has given the check or some challan receipt, yes, we would have been responsible. Nothing was there. There is no record. How can you say that you have given money to him? We can't help. Because on one day, this woman went to the bank and when the bank manager looked at the bank ledger or her account, he was surprised to see that there is no money. The previous clerk has misappropriated the same and he was transferred to some other place. This is the situation. So matter went to the Supreme Court. Supreme Court held that the defendant gave the check at her house and not during the course of employment. If she would have obtained a receipt, then it would have become in the course of employment. Therefore, the plaintiff, that is bank, is not liable to pay compensation. She could not get the compensation. Very pathetic story, but negative example. So you have to know such examples also. With this, I am concluding. Thank you very much.